One of the biggest hurdles that a claimant or a future plaintiff must cross in a premises liability case is liability. These cases are 9 times out of 10 defensed on the issue of liability at trial. And the biggest issue that I see when I have consultations with a potential client is, John Smith calls me, Mrs. Smith calls me, and she says, I'm walking in the restaurant and I tripped because there was a small crack in the floor, or the tile had lifted a little bit and my sandal got caught in it and I went flying and I got injured. Or, I'm walking on a sidewalk in a residential neighborhood and the tree roots have caused the concrete slabs to shift a little bit and my shoe got caught and I went flying and I got injured because of it. There's something called the trivial defect doctrine in California. It's codified in our case law, and it basically gives defendants a way to argue that they should not be held liable because the defect was so small that even in exercising reasonable care, patrolling the property or inspecting the properties, it was such a small minor defect that they wouldn't have ever realized it. In premises liability, we must prove that a landowner or a controller of a property or a tenant or whatnot has notice of a potential dangerous condition so that they can take reasonable steps to either cure it or warn or what have you. So actual notice, meaning you actually knew about that problem, is one thing, but constructive notice is typically how we prove this, in saying, Mr. Landowner, Mrs. Landowner, Mr. Restaurant, Mrs. Restaurant, what have you, you have a duty in California to conduct reasonable periodic inspections, to go check and see if there's anything wrong with your property. And by failing to do so, you didn't find X, Y, and Z problem. That's how we prove these cases. The case law says if you have for example, a 1/4 of an inch difference between 2 elevations and you trip on that, there's a defense for it being a trivial defect. And people don't like to hear that, but the law is what it is. So even though you fall, it doesn't necessarily give rise to a viable case. In any premises liability case, to be successful, we need experts involved at the outset. Somebody calls and says, I got injured, I slipped, I tripped at such and such location. The first person I'm sending there is an engineer to go take measurements, document, do coefficient of friction tests, and determine how slippery was that floor. Does it meet industry standard? Or how deep was that hole? Does it surpass the trivial defect doctrine that I talked about earlier? So we really take an aggressive approach from the beginning in premises liability cases, especially because documenting what caused you to fall and the severity of that dangerous condition is really what can either make or break the case.